Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Monday, October 16th, 2023. We have a great show ahead for you with a special guest and an old-time favorite, and I'll be introducing those folks in just a moment. First, though, this is the first show we've had in a few weeks that wasn't a special or wasn't recorded live or something like that. So we have a little bit of catch-up of what's going on in this short circuit universe. The most exciting news is that our colleagues at the Institute for Justice just got a couple cert grants from the Supreme Court. So that means the Supreme Court has taken a couple Institute for Justice cases that it did not have to take, but for whatever reason thought they were cert worthy. And one of those is a case that we talked about earlier this year on Short Circuit, and that is a case called DeVillier versus Texas. Bob McNamara, our colleague, talked about it earlier this year, and he will be arguing that case at the Supreme Court, which is super exciting for Bob and super exciting for everyone else here. It's a case, if you remember that episode, about whether you can sue a state when it takes your property and doesn't give you just compensation, which sounds kind of weird that that's a question, but the Fifth Circuit said it was a question, and so now hopefully the Supreme Court is going to set them straight. Also in the Fifth Circuit is a case of ours called Gonzalez versus City of Castle Hills, and that is a case about retaliation, a retaliation claim under the First Amendment. And it is mixed in with questions of qualified immunity and the deference given to the government when they arrest somebody, because the police in that town arrested our client, who was a city council member, when she tried to shake up the status quo there. And so that is also a case that we're very excited has been taken by the Supreme Court, and it will be argued by Short Circuit's own Anya Bidwell, who has hosted the show many times and now gets a crack at those justices on at 1 First Street. So we are so excited that there's two cases from the Institute for Justice going to Supreme Court, maybe more. We have another case that's been relisted a couple of times. But we'll be talking about those, I'm sure, later in the term, even though it's at that Supreme Court and not our fan favorites, the Federal Courts of Appeals. But getting to those Federal Courts of Appeals and fan favorites, I'd like to introduce you to an old-time favorite at IJ, and that is Paul Sherman. Paul, welcome back to Short Circuit.
Thanks for having me, Anthony. It's always a blast to be here.
And we're going to have a blast of the kind of case that Paul often talks about, and that is a First Amendment campaign finance case out of the 10th Circuit that we'll get to a little bit. But first, we have a first-timer here on Short Circuit, and that is Joe Diedrich. Now, Joe lives in one of my favorite places in the world, Madison, Wisconsin. He practices there at Hush Blackwell, the law firm, and does all kinds of interesting stuff. Joe, you want to tell us about how interesting you are?
Oh, great. Thanks, Anthony, for inviting me on, and great to be here with you, Paul. I work at Hush Blackwell. I focus mostly on suing the government and administrative law cases, judicial review cases, and on appeal in particular.
That's right. And Joe has written some amicus briefs for that have been filed in IJ cases in the past, especially in First Amendment areas. Is that right?
That's correct. We've been fortunate enough to do a lot of work with the Institute for Justice, writing some amicus briefs. One recent example is your all's great success down in Georgia in the lactation consultants case. We did an amicus brief in that occupational licensing case.
Well, speaking of occupational freedom, we have a case that Joe's going to talk about here from the 7th Circuit that I have to say is pretty unusual way of looking at occupational liberty, but I thought was pretty interesting. So, Joe, want to tell us a little bit about this?
Yeah, so the case is called Biggs versus Chicago Board of Education from the 7th Circuit. from a few weeks ago. So the plaintiff, Biggs, was a principal at a Chicago public school, and she violated some school policies, including an attendance policy. So the school said you have to keep track of student attendance in this one particular way, and she directed teachers to keep track of it in a different way. The result was inflated statistics for that school and how many students showed up on a regular basis. She also violated a transportation policy that required her to get parental consent before school employees could drive students around, and there was never any parental consent. So she did a couple of things that she shouldn't have, and the school board terminated her employment. And when it terminated her employment, the school board also did two other things. It blacklisted her within the school district by putting a do not hire designation on her personnel file. And then in a couple of public school board meetings, it made some comments about Biggs and her termination and what she had done to get fired. So Biggs goes out into the world and tries to find another job. She tries a couple of jobs within the Chicago school district, doesn't get anything there. She applies for principal jobs in particular. Then she goes out into a couple of other school districts in the Chicago suburbs, can't find anything there. She applies to some different nonprofits and some charter schools, even the Obama Foundation, eventually gets a job at an education nonprofit. And then a few months later, she and a colleague open up an educational consulting firm. But she was never able to get the job she wanted, which was school principal at a public school. So she goes into court and files a lawsuit against the Chicago School Board under Section 1983, alleging that her 14th Amendment due process rights were violated, specifically that the board deprived her of a liberty interest in pursuing an occupation of her choice. Now, the Seventh Circuit goes in and says, look, there is a recognized right to, quote, occupational liberty, the liberty to follow a trade or profession or calling of your choice. And there are different circumstances when such a claim might be available, and maybe we'll talk about those other circumstances in a few minutes. But the claim that was specific to this case was when a public employer takes adverse employment action, like firing you, and then also makes stigmatizing public comments that foreclose future employment opportunities, you can sometimes bring a claim. The standard is very high, though. The court said you have to show that it was, quote, virtually impossible to find new employment within your occupation. And that phrase, within your occupation, is going to be key here. The district court dismissed the case at summary judgment saying, hey, Biggs, you actually got jobs within the, quote, field of education. So we don't even see how you were harmed, really, because whatever the school district might have said about you, you got the jobs you wanted. The Seventh Circuit goes on to affirm, but does so on very different grounds. And this is where the case gets really interesting. They say, like much in the law, it's best to think of an occupation as existing on a spectrum of generality, somewhere between a specific job and a field. And so they go on this rather lengthy discussion about what was Biggs's occupation. And was she prevented from getting another job within that occupation? They say it's a case-specific inquiry. And what I found most helpful to analyze this sort of level of generality problem was the different examples that the court gave. So they said being a police officer, for example, that's an occupation. But a police lieutenant, that's a specific job. And so if you were to analyze a police officer's claim in this framework, you would have to analyze it at the level of police officer, not a specific rank. They also give the counterexample of medicine being a field, a very broad field, and then having nurses and doctors and therapists have different occupations. And then my favorite example of all, they said food service, that's a field. Different occupations within that field would be cooks and wait staff. And a specific job might be a head chef at a prestigious restaurant. So applying that analysis and that framework to Biggs, they said, look, the district court got it wrong here because they analyzed her claim at the level of a field. They said, well, she got a job in education, and therefore she had nothing to complain about. Seventh Circuit said that was wrong. That was much too general. They said what her occupation was school administration, as distinct from, for example, being a teacher. And they looked at things like what degree she had, which was a degree in school leadership. They also looked at the fact that she had a state occupational license to be a school administrator and not a teacher. And then they went on to differentiate that from individual specific jobs within, sort of under that, meaning like head principal, which she was, versus vice principal and assistant principal, for example. So they said the district court got the analysis wrong, but as I mentioned, they ultimately affirmed. And they said that there was two problems at summary judgment. Number one, there wasn't any evidence to show that the Chicago Board of Education made it, quote, virtually impossible for her to find a job as a school administrator because her search was so limited. Apparently, she only applied to a few jobs, and only one or two of those was actually within the school administration occupation, as opposed to other things within the broader education field. She only applied for jobs for a few months and only within this relatively small geography of the Chicago suburbs. And they also faulted her for applying only to principal jobs and not applying to vice principal jobs or assistant principal jobs, things that really were within her occupation. And then the last point they made was that with one exception, there was no evidence of causation. So most of the places she had applied to apparently didn't even know about the allegedly stigmatizing comments that the Chicago board had made in those public meetings right after she was fired. So in the end, I would say a relatively, maybe non-controversial outcome based on her lack of evidence, but a super interesting discussion about levels of generality and about the right to occupational liberty, which is something that comes up in different contexts.
Yeah, I thought it was an interesting case as well. It was kind of like a through the looking glass moment for me as I was reading it, because there's this just radical difference between the kinds of cases that we see at IJ where we're representing people who are employed in the private sector and the kind of expectation that this former government employee had about what her rights were vis-a-vis her former employer. And one of the things that I thought was most interesting about the decision was that there's no analysis, and it doesn't actually seem to have been relevant, that the statements about her were true. Like the statements were, we fired her because of an integrity issue, which seems to be true. And I don't recall exactly what the other statement was. So essentially what she's alleging is that she has this constitutional right for the government as her former employer not to reveal things about her that are true and relevant to other employers that make it harder for her to get a job. And I can imagine situations where even if the statements are true, it seems like the government is going out of its way to sort of tortiously interfere with her ability to find jobs elsewhere. But the notion that just, disclosing, we fired her because she was falsifying these important statistics on student enrollment, it's just kind of shocking to me that can be the basis for a claim.
In perhaps a little bit in her defense, there was a note in the case saying that she disputed the truthfulness of those the claims, and for whatever reason, probably based on the way it was briefed, the court decided it in this way rather than getting into the factual dispute. But you raise a great point, Paul, because this really does differ from a lot of the other sort of occupational liberty cases that folks like the three of us may be interested in. I mean, this was a very specific job that she was terminated from based on, very as applied conduct from government to her versus the other types of occupational liberty cases that we might be familiar with, where there's a generally applicable rule of conduct, usually passed by a legislature or maybe put in place by an administrative agency, is saying, for example, you need a particular licensure in this state if you want to work as a florist or as a lactation consultant or as a pick your occupation, and you have to go in and you have to show basically not only am I unduly burdened by that, but that anybody in my similar circumstances are unduly burdened. Both have high standards, whether it's the rational basis test for that legislative challenge, or here as the virtually impossible test for the sort of specific to one person challenge. But there is a difference in that causes some legal tension, I think.
Yeah, there are so many things I think that could be said about this case, Biggs, in comparison to the types of occupational liberty cases that we do at IJ. And for listeners who are somewhat familiar and interested in the kind of work we do at IJ for occupational liberty, I'd really encourage you to read this case. And it's always, there's a link to it in the show notes, because it's like Paul said, it's like through the looking glass in a lot of different ways. If you're used to the kinds of claims that we bring at IJ. I mean, when Joe first mentioned this case to me, I thought, well, that sounds like one of these procedural due process new property cases, which some listeners may be familiar with. There's this idea in the law, that the Supreme Court's come up with the last 50 years or so, that if you're a government employee and you are unceremoniously or for whatever reason let go or demoted or whatever, and you're not given proper due process, so that could be a hearing, it could be all kinds of different things depending on your station in employment, then you might have a claim against the government. Now, I guess this woman was an at-will employee, it turns out, so she dropped that claim, but she did bring that claim. But then there's this other claim, and the interesting thing about this claim is although most of the jobs that she was applying to were other government jobs, not just with Chicago School District, but with others, it seems like it would apply to the private sector. So if she was applying to be a principal at a private school, this same claim would apply, which makes it sound like the kind of thing we challenge at IJ, which is government action unreasonably barring you from employment. And almost always when we do those kinds of cases, it's involving private employment. But it seems like it's a due process claim, but it's like this whole different test and this whole different idea. And, they don't mention rational basis or tiers of scrutiny or anything like this the whole time. It's just this three-part test that it sounds hard to satisfy, virtually impossible. But actually, considering the rational basis test itself is so impossible that it might be a little better than the rational basis test. Maybe I'm just jaded from litigating some of those cases. Maybe Paul is too. But it's interesting. It's like it's its own being. And it seems like it's just a Seventh Circuit thing from what I can tell. So they cite to this case that is a procedural due process case called Roth from the early 1970s from the Supreme Court. And everything else, it seems like, is the Seventh Circuit, which kind of raises it for those of us who have practiced before the Seventh Circuit, like I know you have, Joe. It's kind of its own animal sometimes. Like there's all kinds of weird due process, equal protection, whatever name it, stuff in the Seventh Circuit that's like its own little universe. And I could pontificate why that is, but it seems like this is an example of that, and it just kind of does its own thing.
Yeah, I would agree with that. I can't speak whether or not there's any other circuit perhaps that does a test somewhat similar to this, but this is a case that seemed largely based on precedent and exclusively based on either U.S. Supreme Court or Seventh Circuit precedent. If you look at the panel here, it's ideologically diverse. The opinion was written by Lee, who is a relatively recent appointee, and then you've got Rovner, who was a Clinton appointee, and Chief Judge Sykes, who was a George W. Bush appointee. So you got people from all over the spectrum with all different backgrounds, and they're all coalescing on this task.
Yeah.
Another kind of interesting, it's not an issue in the case, but it does seem like sort of something that's kind of floating around it is there is an entire doctrine, First Amendment doctrine of government speech. And generally, courts are very solicitous of, the government's ability to express itself on, the issues that it thinks are important and not second guess that. And maybe that's actually reflected in how high the standard is here, that you have to prove that it's virtually impossible to get a job in your field. But it's just kind of another interesting sort of aspect of it that just seems kind of pregnant in the opinion, but isn't discussed directly.
Yeah, it almost seems like, it's another way of thinking about it is it's a libel case against the Chicago public schools for saying this, and that you have this high standard like you would,
Except the truth isn't a defense.
Yeah, well, it didn't come up at this time, at least. I have this other theory about the Seventh Circuit and these weird cases that I'm sure you could do a long article about that I probably will never have time for, but that there's so much like just endemic corruption and bad government in the state of Illinois, not so much Indiana and Wisconsin, both at the state level and especially at the municipal level, that like the Seventh Circuit to deal with that just kind of has this odd take on reality that you don't see in other circuits. And so that's a little bit of what's going on in the background here. I've always just kind of got that flavor that, in Illinois, the federal courts and the U.S. attorney kind of see themselves as like the last best chance for hope. And so they do what they can to kind of just, let the people not give the people a little bit of respite from this morass of corruption that they live under.
Well, I don't have a comment specifically on that. I've got many great colleagues from Chicago, so I won't.
And I practiced there for 5 years, so that's where some of that comes from.
But if I may, just one last thought on this case, which I talked about, but I found to be the most interesting part of it was this lengthy discussion of levels of generality in the law, because we see this in so many different contexts. For example, in qualified immunity cases, what is the right level of generality to analyze whether a right is clearly established for purposes of qualified immunity? And for that matter, anytime you're dealing with a fundamental right or an unenumerated right, how do we define that? How specific are we? How general are we? I would say, Anthony, correct me if I'm wrong, but IJ wants to have a right defined as general as possible, and the government will typically try to make the right more specific to limit it against government action.
That's true. Although, and I did appreciate how the court was trying to be careful in that regard. And, sometimes it can be like for this woman here, when you're fighting the government, it could be that you wanted a little bit more specific because, sometimes we have these occupational licensing cases where the government will say, well, we didn't totally eliminate your right to, work an occupation because you could just go like do something completely different. You could go bake bread, for example, if you're trying to be a florist, and hey, there you can make money over there. So what's your beef with us? And the court here was trying to be, realistic, I guess, in kind of how they define things. So that's another, I think, point of reference between these two types of cases.
Yeah, I think it really does depend, and you're right. The court was very careful, and so for that reason alone, I thought this case was really interesting.
Well, another place where it seems like a court was trying to be somewhat careful is in the 10th Circuit, where we have a campaign finance case. Now, when I first got to IJ like 13 years ago, campaign finance, this huge thing, all this stuff going on. There was Citizens United. There was a case we had at the Supreme Court the year after that our friend Bill Maurer argued, as he likes to remind us from time to time, about from Arizona. about public funds for campaign finance. Then there was a case a few years after that called McCutcheon, which had to do with different kinds of contribution limits. In last few years, it's been pretty quiet out there. And then, so we get this. This is an interesting find that Paul had out in the 10th Circuit in Wyoming. So, Paul, what's going on in Wyoming? But also, kind of, why is this like the only campaign finance news that we've heard in some time?
Yeah, I mean, so in a lot of ways, this case is kind of a blast from the past. It very much feels like the kind of issues that were super hot back in like 2008 and then kind of went away. And so before I get in the case, I'll just give kind of a quick history lesson that will kind of explain the arc of campaign finance and why back in 2008 it was like a major component of IJ's First Amendment practice. And now, we don't have any active campaign finance cases and haven't for a while. Largely, that's a result of our success and the success of other First Amendment advocates in litigating in this area. But this case, Wyoming Gun Owners v. Gray, involves the regulation of what are called electioneering communications. And what an electioneering communication is it's an ad that mentions a candidate or a ballot issue, but doesn't expressly say vote for or vote against the candidate or ballot issue. But we all know what's going on. And these became a hot thing in the early 2000s with the passage of the McCain-Feingold law. So when the feds first regulated campaign finance in the 1970s, went up to the U.S. Supreme Court, and in a case called Buckley versus Vallejo, the court said, this law would be unconstitutionally vague if we don't draw some kind of bright line about what can and can't be regulated. So we're going to say that this law only applies to ads that expressly advocate the defeat or election of candidates. So the ads had to say vote for, vote against, support, oppose, defeat, elect. This was called the magic words test. And it got a lot of criticism because people quite naturally would go right up to the line and they would run these ads that are like, Bill Yellowtail says he supports family values, but he took a swing at his wife. Call Bill Yellowtail and tell him what you think of him. And so in the McCain-Feingold law, which passed in 2002, Congress started treating electioneering communications the same way they treated ads that expressly advocate the defeat or election of candidates. And that was upheld in McConnell v. FEC, which was kind of the high water mark for regulation of campaign finance. Then in 2010, we get the Citizens United decision, and everything changes. Basically what happens is the Supreme Court says you can no longer restrict the financing of these kinds of ads. So corporations, if they want to, can pay money to finance electioneering communications, but you still have to disclose your donors. And that was kind of the compromise that was reached in the law. So the sort of more substantive restrictions on funding the ads were all unconstitutional, but disclosure kind of reigned supreme. And in fact, one of the underappreciated things of the Citizens United decision is that even though it was very closely divided on this issue of whether corporations can spend money on the ads, it was actually an 8-1 decision with only Justice Thomas dissenting on the question of whether they could be forced to disclose their financing of those ads. So fast forward to the modern day, Wyoming enacts a regulation of these electioneering communications and says that if you spend more than $1,000 financing them, you have to register with the state and you have to disclose the donors who funded the ad. Unlike the federal electioneering communication ad law, which only covers broadcast, this covers basically everything, whether it's billboards, cable TV, brochures, emails, websites. But you only have to disclose contributions that, quote unquote, relate to the electioneering communication. And that's going to be central to the decision. So the plaintiff, Wyoming Gun Owners, is this small nonprofit that defends Second Amendment rights. And it has an annual budget between $50,000 and $100,000 a year. So, they're spending some money on these ads, but they're not a huge political player. They're, as the court calls them, they're a mom and pop shop, and they don't have super sophisticated bookkeeping. They've got an account for donations that come in online, and they've got an account for donations that come in by mail. They don't allow people to earmark their contributions, and 90% of their budget comes in contributions under $100. So they want to run this ad, and I'll just read the ad because I think it gives you a good sense of what an electioneering communication is and kind of how close people come to the line without saying vote for or vote against. So here's the ad. America is under attack. Violent thugs are rioting, looting, and vandalizing, pushing socialism for America. Only a few brave champions will stand against them and fight for your gun rights. One of those champions is Anthony Bouchard, a nationally known conservative leader who has always led the fight for Wyoming gun owners. That's why the left hates him. And that's why they are propping up liberal Aaron Johnson in the August primary, hoping that this self-described country club chamber of commerce moderate will help them pass red flag gun seizures in Wyoming. We all know Anthony Bouchard has fought like hell for gun owners. But Aaron Johnson won't even mention gun rights on her website. That's pathetic. But that's Aaron Johnson. Tell Johnson that Wyoming gun owners need fighters, not country club moderates who will stab us in the back the first chance they get. This is Aaron Dorr, and this ad is paid for by Wyoming gun owners.
I think that the tone of voice probably is what pushes it over the edge, if you ask me.
Yeah, so mystery where Wyoming gun owners stands on these candidates and how they want voters to respond. Well, the Greater Cheyenne Chamber of Commerce did not appreciate, apparently, the reference to Chamber of Commerce moderates, files a campaign finance complaint with the Secretary of State. Secretary of State investigates, tells Wyoming gun owners, you got to disclose and register, and we're going to fine you $500 if you don't. And Wyoming gun owners tells them to pound sand. They pay the $500, and then they challenge the electioneering communications regulations. Now, if you had asked me to guess how this case was going to turn out, just based on the facts and what they claimed, I probably would have said the law is going to be upheld. Like, they've got, maybe they have a chance on some of their as-applied claims, but it's probably not a great chance. Lucky for them, they pulled Tim Timkovich on their panel on the 10th Circuit. Judge Timkovich, former campaign finance attorney, expert on campaign finance, and he actually does a very careful and thorough job in this opinion, going through all of their claims, and they have many of them, facial and as applied, looking at them closely, and I think applying the law in a very nuanced way. And I think sort of the upshot of the case is there's been a general perception since the Citizens United ruling that disclosure cases just largely don't win. And I think Timkovich does a good job explaining, no, disclosure is not subject to rational basis scrutiny. It's not subject to strict scrutiny, but it is subject to what's called exacting scrutiny. And that's a meaningful standard that imposes a real burden on the government, particularly when it comes to tailoring their laws. So I'm not going to go through all of the claims that Wyoming gun owners brought, but the kind of the core of their argument was they objected to this related to language about the donations that they had to disclose. They said that this was vague, and then they also said just it imposes this undue burden on us in making disclosures. And the court rejected those arguments facially, but as applied to Wyoming gun owners, it accepted them. And it said, look, the law, they're in compliance with everything they need to be doing accounting-wise. But it's completely unclear which contributions they receive that are, quote unquote, related to these ads. And the state's response to that was just, well, they can avoid that vagueness by just disclosing every contribution they receive. Easy peasy. And the court says, no, that's not how exacting scrutiny works, because there you're just trading the vagueness for over-disclosure. And this is something that I think gets lost in a lot of campaign finance decisions is, most people, when they give unrestricted funds to an organization, I think it can be very misleading for that organization to say like, oh, this ad was funded by this person, because that person frankly doesn't know about it.
Probably has no idea it was going to be done.
They may support the organization more generally, but I think it's wrong to impute that specific message, which was chosen by the group, to that specific donor. So one of the, I think, most interesting things about the decision is that it takes a close look at a recent Supreme Court case called Americans for Prosperity v. Bonta. And this was a case that IJ did an amicus brief in, and I was a little disappointed with the outcome in that case, or well, not the outcome, but the reasoning in that case. But Timkovich, I think, really wrings the most out of it that he can in a way that is very speech protective. So AFP v. Bonta dealt with a California policy where if you were a nonprofit registered in that state, you had to disclose what's called your Schedule B to the state. 501c3s and C4s have to file this form with the IRS, and it contains a list of their biggest donors. And California, as it turns out, was terrible at maintaining the confidentiality of these documents. A bunch of people's Schedule Bs got leaked to the public. And Americans for Prosperity sued and said, we should not have to disclose this. They won at the U.S. Supreme Court under exacting scrutiny. Now, we had argued in our amicus brief that the whole exacting scrutiny applies to disclosure thing was just a campaign finance thing. Campaign finance is kind of this sui generis area of First Amendment law where the court has made a bunch of exceptions to general First Amendment principles, and it shouldn't expand that outside of that narrow context. And we hoped that the court would say, outside of that context, strict scrutiny applies to compelled government disclosures. And part of this is the Supreme Court has used the phrase exacting scrutiny to refer both to strict scrutiny and to intermediate scrutiny. And as a result, there was a ton of confusion in the law. Instead, what the plurality in Bonta said is, no, exacting scrutiny is a form of intermediate scrutiny, but it's one with teeth. And Justice Alito in his concurrence, reinforced that as well. And so this particular disclosure, we're going to hold as unconstitutional. I would not have expected that to sort of come back and play a major role in campaign finance decisions where, courts have been so forgiving of the government and its justifications for these disclosure laws. But Timkovich really latches onto it, and he applies exacting scrutiny in a meaningful way. He says that, the government has not really attempted to narrowly tailor this law, and it does impose sort of serious burdens on these unsophisticated mom and pop shops. So long story short, Oklahoma's law survives facially, but as applied to Wyoming gun owners, it is unconstitutional. A pleasantly surprising outcome, and definitely a very much a blast from the past. I read a bunch of these cases in the mid 2000s, and it was a nice walk down memory lane going through this one.
And you litigated some of those cases, including one that they mentioned a few times, our Parker North case from Colorado.
Yeah, so there is another 10th Circuit case from 2008 called Sampson v. Boisher. One of the earlier cases I worked on when I was at IJ, and that case was about a group of neighbors that spent like $782.02 advocating against the annexation of their neighborhood, Parker North, into the adjacent town of Parker, Colorado. And as a result, the main proponents of the annexation filed a private enforcement complaint against them in Colorado. This is a separate story. Colorado had a privatized system of campaign finance enforcement, which IJ later succeeded in having struck down as unconstitutional.
Which Paul may have also litigated.
I may have litigated that one. But anyway, in Sampson, the court said, look, as applied to this very tiny group, just neighbors essentially getting together and pooling money, you can't force them to go through the formalities of registering with the state, setting up a separate bank account, behaving like a full-blown political action committee, just because they want to get involved in politics. That's too burdensome for that kind of organization. Here, the panel distinguishes Sampson and says Sampson really was just neighbors getting together. They were not, I spoke with them and, they were not politicos. They were just people who spontaneously came together and cared about this issue. This is really a policy group that's established, and it's taking in $50,000 to $100,000 a year. It's not unreasonable to expect it to do some kind of registration and disclosure, at least under existing Supreme Court precedent. At least in this case, as applied, the vagueness of the law and the relating to is what made it unconstitutional, as opposed to the pure burden of compliance.
Right. Joe, do you see this as fairly burdensome with how things are run in Wisconsin?
Well, I certainly think it was burdensome on any small organization. I mean, the discussion about how the Wyoming group kept its accounts, right? It had really only two accounts in the whole shop, and it was one for help me, Paul.
One was online donations and one was mailed-in donations.
Right, and that seems reasonable, I think, to anybody who's only operating on a $100,000 budget, but that made it sort of impossible to comply with the law, and you'd have probably a much bigger shop before they start breaking down accounts in a way that would have been so. So yeah, I think the burden analysis sounds spot on. Another thing that I found interesting, the majority of the case was talking about exacting scrutiny and comparing the governmental interest with the burden. But there was also the earlier discussion of vagueness and the phrase relate to and how that could be applied, at least in these circumstances, in a vague way that would lead to arbitrary enforcement. And they really didn't know how Wyoming might enforce that. And I thought that was also a good and correct analysis.
Yeah, I just a couple of reactions. Number one, with these campaign finance laws, like they are generally written with a view towards the big players. Like this is a law that's written to regulate the NRA, and what we expect of the NRA is different than what we should expect of Wyoming gun owners, this tiny mom and pop shop. The NRA is a super sophisticated, highly funded group that, they can deal with some of these burdens in a way that smaller groups can't. And if we aren't sensitive to that, then what ends up happening is that we allow only established and sophisticated political speakers to participate in public debate. And that's a huge loss to our political culture. And then just one quick comment on related to, just a notoriously vague phrase in the law, as anyone who has ever done, discovery knows, because you get these discovery requests that say, we want every document related to blah, blah, blah. And invariably, everybody objects and says, what the hell does related to mean? What's the level, going back to what's the level of generality at which something relates? So not surprising that the court, particularly in this situation where First Amendment rights are at stake and we expect more clarity generally from laws than we do in other contexts, not surprising that the court was not very sympathetic to the government's claims that this was clear and easy to understand.
Yeah, this is a little bit of a broader comment, but the idea of something being vague as applied has always kind of befuddled me a little bit, because part of the vagueness doctrine, right, is that you don't have fair notice of what's required of you. And that seems to really lend itself to we're looking at it as considered for the entire regulated community, not for one person. So I don't know if you've ever given any thought to that, but I don't know. It's always kind of confused me a little bit.
Yeah, it's not something that I've thought about in a while, but it is something that we have encountered in our cases and briefed. And I remember reading cases about it, some Supreme Court decisions discussing it. I know there's a discussion of it in the Supreme Court's 2010 ruling in Holder versus Humanitarian Law Project, which is very, very different factual context involving advice to expert advice to terrorist groups. But yeah, it is kind of a befuddling doctrine. I think another, not to get too deep in the weeds, but another area where I think there's confusion in the law is the distinction between overbreadth in the sense of substantial overbreadth and narrow tailoring as a component of strict scrutiny. They're all these doctrines kind of relate and intersect, and it can be really difficult to suss out how they should apply in specific cases.
Paul, do you see this as a little fact bound to this peculiar language that in the Wyoming statute, or do you see this kind of the making sense of the Supreme Court's latest statements in this area to be something that we're going to see increasing litigation on, or a split perhaps developing?
I probably the former. I think certainly the U.S. Supreme Court, it still issues campaign finance decisions from time to time, but it does not have the kind of appetite for it that it did during the 2000s and the early 2010s. So I don't think we're going to see and frankly, just a bunch of these laws have already been litigated over and upheld.
Right.
And there hasn't been, at least in recent years, major pushes for new campaign finance regulations. So, Wyoming is maybe a little unusual in that it's adopting an electioneering communications law so late in the game. So probably this doesn't herald a major change. I think it is a signal to states that if you want to be active in this area, you got to read those Supreme Court decisions closely. And you have to draw your lines carefully, at least in the 10th Circuit, where we're going to take a close look at this. If you're in the 9th Circuit, you can write whatever you want, and we'll rubber stamp it.
Well, thank you both for reading your decisions closely today. Joe, it was great to have you on. Joe was very courteous hosting a talk that I had, a panel I was on about my book a few weeks ago in Madison. And thank you again for that, and for coming on Short Circuit and all the work you've done for IJEC.
Well, thank you for having me on, Anthony. This has been great. And I don't want you to get any angry letters or comments, so I'm going to correct myself right now. I think I said earlier that Judge Rovner was a Clinton appointee. That sounded wrong when I said it. She's actually appointed by George H.W. Bush.
That's right. That's what I thought. But I didn't want to dive in. But she is. I mean, I think it's well put that she's been usually found to be a fairly moderate Republican appointee,
sure.
and not someone you can pigeonhole or predict. And so it's definitely a cross ideological panel, as you described it. And Paul, thank you for coming on and enlightening us on some blasts from the past. And I'm sure we'll have you on soon with some more First Amendment news that we think may be coming soon from the either the Supreme Court or the federal courts of appeals.
Yeah, it was great. I spent the first half of my legal career almost exclusively working on these campaign finance cases, and I from time to time lament that I've developed this expertise in this very esoteric area of First Amendment doctrine that just doesn't get litigated very much anymore. So it was nice to flex those muscles a little bit, and I'd be happy to come back anytime.
Well, you can flex any muscles you want on Short Circuit, especially because we're a podcast. So thank you both, and thank you for listening, and we will talk to you next time. But until that time, I'm asking that everyone get engaged.